I had been working for CNA Insurance Company, originally in the state of New York, and I gotten promoted to a position in the home office claims department. And then in 1999, the personal lines division of CNA was bought out by Allstate Insurance Company, who's also located in the Chicago area. And as a result of that buyout, I was approached and offered a position to manage the implementation and oversight of Allstate's version of Colossus. So that's when I really got involved with Colossus on a full-time basis. Basically, what Colossus is just a series of questions that it poses the adjuster. It asks the adjuster all about the details of the injury, of the injured person, the type of injury they have, the extent of the injury, the amount of treatment, the outcome of that treatment, etc. And so, depending, of course, of what that adjuster inputs into the software will determine what comes out the back end as far as the recommended value. If you're initially setting up Colossus, you go through a process of initially setting up the tuning by going through some sample cases and determining within that particular insurance carrier what they think those particular sample cases are worth. That kind of sets a baseline tuning, and then the insurance carrier would run additional cases up against that baseline tuning and see what the projected results would be. So that began in 1999, and then going forward, as I got deeper into it over the years as they progressed, I questioned some of the things that I was involved in as it pertained to Colossus and how the program was being utilized. CNA Insurance already had Colossus. However, Allstate had done some analysis and had determined that if CNA Personal Insurance utilized Allstate's Colossus tuning versus the tuning that currently existed in the system, as well as adjusting some of the protocols, in other words, the way things were input into the system and so forth, that over a 3-year period, they projected that they could save approximately $33 million by utilizing what I just stated. So it was my responsibility to go in and implement it and to meet those goals, which is what I did. I speak about that a lot in detail in the report that I co-wrote with Robert Hunter, the Director of Insurance of the CFA. I outline in that report ways that the Colossus software can be manipulated to favor the insurance carrier and to the detriment, of course, of the policyholder or the third-party claimant. And it can be done through either direct, what I refer to as direct manipulation, which basically means that you're directly manipulating the tuning to reduce the recommended settlement values, or indirectly manipulating the recommended settlement values and future tuning by what being allowed to be input into the software when the adjusters are inputting information on claims. So if you train your adjusters in a certain fashion, or you restrict what they can put in a certain way, then the outcome or the recommended settlement value on the back end can be controlled. The way that you can directly manipulate the numbers, and I'm talking hypothetically here, of course, and not specifically about anything, would be to, it's basically a mathematical formula, and then you would input a set of variables, as they're referred to in the Colossus vernacular, into the programming, and what it would do is it would reduce the recommended settlement value that would come out the back end of the system. So basically, you would program the software to spit out a lower number. And if they take a look at those projected results and they feel that they're too high, for example, then they could program the tuning to be reduced by a particular percentage.
It sounds like what Colossus certainly had and has value in terms of analyzing the data and having some way to evaluate the claims. But I believe that what you're suggesting is that they also had an override function where if that data was not possibly what fit best for the insurance company, they could just categorically say, well, you know what, let's just reduce that 20%. Is that something that was done?
that's something that could be done. I'm not sure that I feel comfortable saying at this point whether or not it was done.
Mark, let me ask you something. Why did you leave Allstate?
Well, I mean, it's multiple factors. The last few years that I was working for them, my health started to deteriorate. I was just feeling more and more stress. A lot of it had to do, I believe, reflecting back on it, on a lot of the things that I was involved in with my work and feelings that I had in regards to what I was doing there. I began encountering a lot of health issues, specifically migraine-related issues. And at a certain point, I ended up even having to go out on disability for a short period of time, in and out a couple of times, actually. And given the concerns I had with my health and the way I was feeling about the work that I had been involved in previously over those years, and just a desire to get back into a situation where I could truly help people again, I decided that it would be best if I left the company. And so that's what I did. What
recommendation do you have for trial lawyers? How do they combat something like Colossus? How do they go up against something like that?
What they can do is educate themselves as best as possible in regards to how this program works. Colossus, for example, has a feature that allows the adjuster to put in a permanency or a percentage, body as a whole permanency. Well, that is what's referred to within the Colossus business as a value driver. It adds significant dollars to a recommended settlement value when you start adding in permanency ratings into Colossus. And so some of these cases I've seen where people are obviously permanently injured, I'm seeing where the insurance carriers or the adjusters are not inputting permanent impairment ratings into Colossus. Therefore, they're basically manipulating, or they're intentionally keeping the recommended values down on those cases. And it's not just this program. There's other programs that work in tandem with this, and just understand as much as possible what is going on behind the scenes so that they can assist their clients as best as possible and recover as much as possible on their behalf. I think it's disgraceful, especially when you're dealing with a claim where the attorney is representing a policyholder. I mean, it's disgraceful in any circumstance, but especially one where there's a contract involved between a policyholder and an insurance carrier, and they're not holding up their end of the bargain. It's just wrong.